Welcome to our final chapter in our series playlist, Divorce Deconstructed. And that final chapter, a contested divorce trial. So here's the intro. It's unlikely you're going to get there, okay? I don't know what you're seeing on court TV or celebrity TMZ, divorce family law, but in Cook County, Chicago, Illinois, my area of expertise, place where 80% of our practice is, the latest data is 5% of divorce cases end in a trial, right? Correct. 95% of cases do not get to this stage of a contested trial. The other second part of my introduction would be figure it out early if your case might need to get there, and some do. Some do, don't get me wrong. I mean, there's some important issues in those 5%. But warning, kind of don't let your case just get there unintentionally. And that's my point of emphasis, because this isn't the exact numbers. The 5% of cases in Cook County getting to a trial that's actually government data. Something like 80% of the time I'm involved in a trial, it's not because it should or needs to get there. It's sort of unintentional in the sense of maybe part of the case or the other side in a case is just, maybe they have a bad lawyer. Maybe there's just kind of like emotions and combativeness and that sort of thing. But usually in that 80% of, I'm calling them unintentional trials, I'm setting a trial date because the case needs to get done. And I'm just putting a period at the end of the sentence so my client knows this case is going to be over 3 months from today when we have a trial date. And then a lot of times that'll force a settlement. But the better practice is don't get into that situation where you're in sort of that, I'm calling it the unintentional, unneeded trial, because what is not being said in that unintentional trial is that usually it's like we've gotten into a case after another attorney and the case is dragged on forever. And you know, my client's goal is let's get this thing done. And my strategy that's needed to get a case done oftentimes is, okay, we're going to set a trial date. And if we have to actually do a real trial, we'll do it. Okay. So what does an uncontested trial look like if you get there? So here's my substance. First, when is it needed? When is it needed? Can't answer all of the when is it needed, but let me put a few bullets to help you. First, there's a fundamental difference of opinion on child custody, you know, kind of like who's going to be the majority parent of little Jenny. That's a trial. That's when a trial is needed. That's a bridge that, right, you're not going to settle that. If you want little Jenny to be living in your school district with you 70% of the time, and so does the other party, that's a trial. That's going to be a contested trial. In the financial side of a case, there are fewer areas where I tend to see the need for a trial. I mean, the child custody stuff, if you have a big disagreement on that, that's a trial. That's a reason, and frankly, a good reason to have a contested trial. On the financial side, when is it needed? I would say sort of when you have big differences on sort of like valuation, what is something worth issues? How much income does somebody have issues? Sort of, I'm going to call them gray, a little bit unpredictable financial issues. What I'm thinking about here would be value of a business, value of real estate, and perhaps somebody sort of like they have different, various and unclear sort of income business interests. That sort of a case. The person with 4 small businesses that he or she owns in different states, and it's hard to track that type of a person. Even myself, I have a couple of small businesses, right? I look different than this attorney who is just getting paid a salary by some law firm. So child custody, I would say some of those gray financial issues involving valuation and business ownership. Then I guess just lastly, when is it needed? I just wrote down in my notes here, sort of like a zero trust situation or a zero ability to negotiate situation. And those are sad situations because those are the cases where my objective lawyer hat would say trial's not needed in this case. But sadly, you often see cases that get there and it's only because of that. It's like I can't talk to my wife or husband and I trust nothing that they say. And it's just super high conflict, super combative. And then therefore, right, everything's going through a judge, and including final contested divorce trial. So I hope that gives you some guidance on when is it needed. What does it look like? Well, it's a couple afternoons in a courtroom with lawyers, judge, and witnesses. Okay. What am I doing as a lawyer? My big prep is, right, I'm preparing witnesses. I'm deciding who my witnesses are, right? It's always going to be my client. And I don't know, thinking of just some examples of cases we've had, jotted a few down, some of my best hits from over the years. Case where we had a real estate appraiser as a witness, right? Speaking to kind of those valuation issues. I remember a case where we had, it was an issue involving kind of one parent wanted to move the child to another state far away from Chicagoland. I think it was Colorado or Wyoming. And one of the parents wanted the child to stay here. So part of that case involved like, why did our client want to move to Colorado? There was some job related stuff. So I remember having her boss, and I think she'd remarried. So her new husband was already out there. So there were ties to Colorado and reasons why she was moving to Colorado. So that was another example. We have a case right now where it's actually set for trial in the near future, where it's business valuation things. So we've had to have an expert kind of accountant, forensic person look at the finances of a business and value a business. Business has value, right? I think it's stating the obvious, right? A McDonald's franchise costs a lot of money to buy. And so, if somebody has a good operating business, that has value. That's part of the divorce case. So, and then just lastly, I'm just looking at, I can think of a real contested child custody case where a guardian ad litem, GAL, was appointed. And so the reason a court appoints a GAL is to do some investigating around these families, and a GAL can be a witness on a child custody case. Excuse me. So when is it needed? What does it look like? Kind of that witness picture, thinking about getting ready with exhibits and things like that, right? Bank statements, credit card statements, maybe child custody evaluations, things of that nature. Another point would just be, and frankly, a reason to avoid getting to the point is it's very unpredictable. I think that's what people don't realize who haven't been through it, because I just wrote down kind of in my notes, it's like there's the real world facts that kind of like everybody knows. And maybe they in fact are the facts, the real world facts. But a courtroom and a trial oftentimes actually doesn't get the real world facts out there. And that's what you need to be careful about and think about. I'm calling them like court facts, right? The rules of evidence, there are limits on what I can present as an attorney. And the other point would just be sort of like, how does a person present themselves? That's a big issue. And in the last year or so, I can think of 2 contested hearings we had. And I'm not going to go into a lot of detail because I don't want this video to go too long. But if you would have asked me before these 2 hearings, these 2 contested trials, like what the judge would have done, I would have predicted the opposite of what actually happened. And what was the reason the judge went the way she did on each of these cases? Different judge, both were females. I fundamentally would simply say it was like the one case I thought was going to go, well, it was all down to how the particular people and clients and opposing parties presented themselves in court. How does a person look? How can a person verbalize? That really impacts kind of nonverbals. That whole thing of like credibility is a big thing. So when is a trial needed? What does it look like? Emphasis, it's very unpredictable. And then how does it end? Well, oftentimes a judge will issue a ruling that day, right? I'm in a courtroom for these 2 afternoons of trial, case ends, closing statement, and judge will issue a ruling right there. More often than not, if there's more complexity, the better judges will take it under advisement, and probably a month to 2 months later, you will get a final, judgment ruling on your case. So just in closing, sometimes a contested trial is important and very necessary. If your case is there, make sure it needs to be there, and it's not one of these unintentional contested trials. Then the other statement would be, even if you need a contested trial, if they're good attorneys on the case, even that contested trial, you're going to be able to stipulate to a lot of things and get the issues that need the hearing or need the trial really, really narrow to efficientize the trial, right? If you have a divorce case where you're dealing with, child support, spousal support, how to divide property, attorney's fees, significant decisions for a child, parenting time. What was that? 6, kind of the classic big issues on a case. Very frequently, in my experience, maybe 4 or 5 of the 6 are agreed to. So get that narrowed, and even a lot of the facts are agreed to it. Get it as narrow as possible, where it's like, hey, judge, this is the thing we're disagreeing about. We're disagreeing about how property should be divided. And then you have a very tight, narrow trial where it can be done more efficiently in terms of cost, time, and just kind of that get to the closure, get certainty on some issues, even if you're putting something in the judge's lap. So I'm going to leave it there. Divorce deconstructed. What does a contested trial look like? I hope that helps.